Bob Lawry, who runs the Ethics Center for the university, and he's also in the midst of doing scholarship on the Control Council Law Number 10 judgment trial. So he's one of the many people at the law school involved in our international law program, and he'll be moderating this panel. Bob? Michael.
Good morning. My job is to simply give you a brief introduction to each of the three panelists. Larger biographies are in your materials. Then I'm going to step aside. Each of the speakers will talk for 20 minutes apiece, seriatim, and then I'll come back up and sort of direct traffic as we have a Q&A for about 15 minutes afterwards. David Sussman received his Ph.D. in '99 from the University of Chicago. He's assistant professor of philosophy at the University of Illinois at Urbana-Champaign. Botched that, didn't I? His primary research interests are in ethics, moral psychology, and practical reasoning. He recently published an article on the subject matter of his talk, What's Wrong with Torture, in the winter 2005 issue of Philosophy and Public Affairs. Henry Shue, in the middle, first wrote about torture in 1978 in Philosophy and Public Affairs, an article which has been frequently discussed and anthologized. He's best known for a book on basic rights. Henry's been a leader in the development of international normative theory, which he now teaches at the Department of Politics and International Relations at the University of Oxford. His talk is entitled Exceptionalism, Torture American Style. And Jeff McMahan is a professor of philosophy at Rutgers University. He received his M.A. from Oxford, his Ph.D. from Cambridge, and is currently working on a book on the ethics of killing in self-defense in war and as a mode of punishment. Jeff's talk is entitled Torture, Morality, and Convention. We will begin immediately. David.
Thank you. In the genealogy of morals, Nietzsche observes that only that which has no history can be defined. Torture has a long and varied history, and it has indeed proved surprisingly resistant to any very clear definition in current debates about its use and possible justifiability. In the United Nations Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment, torture is defined as, and I'm abridging a bit here, any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. It does not include pain or suffering arising only from, inherent in, or incidental to lawful sanctions. Unfortunately, the Convention does not address the central question of just what is to count as the infliction of the requisite sort of suffering here, or the broader context that might have to be in place to distinguish torture from other forms of coercion, manipulation, or intimidation. Donald Rumsfeld has claimed that the humiliations of Abu Ghraib were not, technically speaking, torture, but merely abuse, although he has yet to explain just what the technical distinction between torture and such abuse is supposed to be. In Northern Ireland, Britain employed what it called interrogation in depth against suspected IRA sympathizers, using techniques that have since been taken up, came to be taken up by Israel and the United States, which go by the term sometimes torture light. Such interrogation involves the hooding of prisoners or other forms of sensory deprivation, keeping prisoners in a room pervaded by the din of a large engine, fan, or loud music, depriving prisoners of food, water, sleep, or medical care, pain medication, and forcing them to stand at great lengths or to assume and maintain stress positions. In the British case, the European Court of Human Rights ultimately concluded that these techniques, while indeed constituting inhuman and degrading treatment, were still, quote, not quite torture, although Israel's Supreme Court ultimately came to largely opposite conclusions. Similar questions have arisen with regard to keeping prisoners naked or in darkness, subjecting them to extremes of temperature, prolonged questioning or isolation, or the administration of disorienting drugs, shaking, shouting, or mockery and threats directed to things they hold dear, particularly their families. One might also wonder whether amputations or sterilizations conducted under anesthesia would count as torture, or the use of things like tasers and pepper spray to subdue inmates, or detention in squalid and evidently unsafe conditions. Much recent discussion of torture focuses on the severity of suffering involved. And this is back to the Bybee EU memos. Bybee argues that to constitute torture, physical pain must be inflicted on a captive, quote, of such an intensity akin to that which accompanies serious physical injury, such as death or organ failure. Now, just what Bybee has in mind here is not entirely clear. It is hardly obvious that there is any distinctive level of pain that is associated with death. One can die painlessly. Or organ failure. Here, the degree of pain would seem to have much to do with just what organ failed, in what way, and in what broader context. I mean, what if it were your brain that was failing? That would probably make a difference. Section 2340 of the U.S. Code also recognizes the infliction of prolonged mental harm as torture, where this harm results from the threat of physical pain or death, the administration of mind-altering substances, or the threat thereof, or the threat another person will be subjected to any of these things. Bybee interprets this condition to mean only that when such harm actually engenders some long-lasting psychological disorder can they constitute torture. This construal is not very plausible. On this reading, a person could not have been psychologically tortured if he died during or shortly after his interrogation. Whether torture is occurring in a case would come to depend on such seemingly external factors as the victim's overall psychological resilience or the future availability of effective psychotherapy and medication. Now, there are no doubt better understandings of severe mental and physical pain than what Bybee offers. These are a couple of fish in the barrel. However, in the remainder of my remarks, I want to consider torture in light of another relatively neglected connotation of suffering, passivity. What is distinctive of torture, I'd like to suggest, is not just the infliction of intense pain, however that is to be understood, but the experience of a kind of forced passivity in the context of urgent need, a context in which such passivity is experienced as a kind of open-ended exposure, vulnerability, and impotence. In order to make sense of some of the difficult cases above, we need to consider not just the intensity of the pain that might be inflicted upon someone, but the alienation of the victim from his own bodily and emotional life that forced passivity before pain and fear can engender. Okay. For torture to occur, its perpetrators and victims must see themselves as standing in a particular kind of relationship with one another and understand that the other understands this as well. Characteristically, victims of torture see themselves as being completely at the mercy of their tormentors. The victim of torture must be unable to shield herself in any meaningful way, and she must be unable to effectively evade or fight back against her tormentor. I might intentionally inflict great pain in a fight in order to make my foe do something. I might gouge his eyes in order to get him to stop choking me. Nevertheless, insofar as my opponent in this case is not helpless before me, my eye gouging, I don't think, is an instance of torture, even though I am trying to force him to comply with my evident desires by inflicting pain. Police who use tear gas to disperse a crowd are not engaging in torture, regardless of how irritating or painful exposure to the gas may be. In these cases, the victims still have it within their power to resist or mitigate the violence done to them by retreating, devising ways of protecting themselves, or countering their assailants with new threats of their own. In contrast, the torture victim realizes that he has no room to maneuver against his antagonist, no way to fight back or protect himself, and he must realize that his antagonist operates in an awareness of this as well. The victim takes her tormentor to be someone who can do anything he wants to her, who does not have to worry about answering any challenges or claims that the victim or her representatives might effectively press against him. The torturer confronts no moral or legal impediments stemming from his victim's will, but is limited only by his own desires and interests, or the desires and interests of those he serves as an agent. The most intimate and private parts of a victim's life and body become publicly available tools for the torturer to exploit and enjoy as he will. The victim is completely exposed, while the torturer is free to conceal or misrepresent anything he likes. Typically, victims are kept, sometimes quite literally, in the dark about where they are, why they are being tortured, who might be making the ultimate decisions about their fates, how long they've been confined, whether it is day or night. Here, the asymmetry of power, knowledge, and prerogative is absolute. The victim is in a position of complete vulnerability and exposure, the torturer in one of perfect control and inscrutability. Torture, even of the light variety, strives to immerse its victim in a world of absolute arbitrariness and unpredictability. Anything may be done to the victim at any time. Questioning may be inexplicably abandoned or shifted to obviously pointless subjects. Periods for eating and sleeping may be shifted or interrupted without warning. The environment may suddenly go from hot to cold and back again. Escalating pain and threat may inexplicably be assuaged with some small seeming kindness or gesture of camaraderie. Okay. Normally, a human being, or even an animal, confronts the world as an arena of action. The world presents itself as a broad context of threats and problems, but also as a fund of resources, in which the creature sees open-ended possibilities of meeting its needs and responding to these challenges. Our emotions are the ways in which we see a situation as calling for some sort of response, as a sort of task inviting the exercise of our powers. Pain and pleasure are something like our most basic awareness of the degree to which these basic powers and capacities are being successfully realized in our environment. The thought here, what I'm offering, is fundamentally Aristotelian. A living thing just is a dynamic system of activities of perceiving, evaluating, and responding to an environment. A system that aims to maintain itself, to maintain that system of activities, relative to various impediments and opportunities. Now, this definition of a living thing has an evident circularity, but I don't think it need be vicious, at least if we can say more about just what these characteristic sorts of impediment and opportunity are, and what might count as the relevant sorts of response to them. However, such ongoing self-maintenance is not what the torture victim experiences. The victim's physical world is controlled so as to make it impossible for him to orient himself practically. That world is designed to close off any hope that the victim might harbor of coming to understand what he sees or of coming to learn more at his own initiative. He cannot hope to find out what is going on, and he can no longer approach his physical world as a context of potential resources or an arena of action. The torturer makes his victim experience a world that he cannot affect except in the very specific ways that the torturer is trying to elicit. The victim cannot fight back, cannot seek new tools, weapons, or strategies, cannot appropriate new materials to his uses. His situation is evidently dire. He confronts it as something in which he must do something. Yet his basic capacities of perception and action confront not just a difficult or confusing world or a hostile world, but a world that is manifestly designed and is clearly going to be readjusted in response to him to give those powers no purchase. Normally, we experience a kind of primitive unity of our emotions, bodies, and actions. We are our bodies. insofar as the body is the substance in which we express our emotional responses to the world in our actions. But the normal context of torture systematically negates this primitive expressive unity of mind, affect, and body. Unable to investigate or strive against the world, the torture victim instead confronts his own feelings and his own body as now the primary source of threats and resources. Living agency is thus turned on itself, struggling not with its world through its feelings, normal condition, but with its feelings as if they were its world now, the external world. Body and emotion are no longer integral parts of the victim's agency, but instead become what the victim, insofar as he can be perceptive or active at all, must exert himself against. As torture progresses through greater pain, fear, disorientation, and hopelessness, even the victim's body and emotions cease to be understood as such an arena for action. The natural progression of torture is to make the individual come to experience his body and feelings as being just as impossible to resist or strive against, just as he had been made to experience the physical world as impossibly alien and unmanageable. Elaine Scarry in The Body and Pain, which, if you know, you realize how much my remarks owe to her and that work. Scarry notes how in prolonged and acute pain, the body often begins to interpret all sensations as pain. The self, that is driven further inward, ultimately becoming not a locus of activity, but rather a point of pure passivity, a vanishing point defined by the direction of the outside forces that have taken on had taken on the basic aspects of what had been his basic powers. The victim does not act through his body on the world. Rather, the world acts through his body on him, where that him is now comes to be experienced as just a locus of suffering, as just the thing that has to take it. A CIA interrogation manual describes this condition as the debility dependence dread state, marked by limitless and unfocused anxiety and helplessness. This is the state which the interrogator is striving to achieve. And it's a condition that results when the victim is, quotation from the manual, cut off from the known and reassuring and plunged into the strange. In At the Mind's Limits, Jean Amery recounts his torture at the hands of the Nazis. For Amery, the experience was pervaded by, so quotation, astonishment at the existence of the other as he boundlessly asserts himself through torture, and astonishment at what one can become oneself, flesh and death. The tortured person never ceases to be amazed that all those things one may, according to inclination, call his soul or his mind or his consciousness or his identity are destroyed when there is that cracking and splintering in the shoulder joints. That life is fragile is a truism he has always known, but only through torture did he learn that a living person can be transformed so thoroughly into flesh, and by that, while still alive, be partly made into a prey of death. I do not think that the sort of living death that Amery refers to here is just a rhetorical flourish. If what I have said so far is correct, Amery's description may be quite literally accurate. What Amery seems to have experienced is not death. That is, not the cessation or absence of thought, movement, consciousness, activity. Instead, Amery seems to have experienced something like the opposite of life, a kind of active awareness of himself as a mere thing, as nothing more than that which is acted upon, a mere medium of another's boundless assertion. Normal death at least has the solace that when one's living is over, so too is one's ability to be aware of oneself as such. In torture, however, right, the great solace that the Epicureans pointed to. In torture, however, the victim remains alive to himself as a point of absence that confronts what had been himself, his body and his feelings, as a fundamental threat to himself. A living thing, I claimed, is essentially a system of activities meant to sustain itself through changes and disruptions in its environment. In torture, this relation is characteristically reversed. The victim experiences himself as boundlessly threatened, but there is little for that threatened self to be, but simply that which is so threatened. If life in general calls for a special kind of respect or concern from us, and that's a big question, but it's not a crazy suggestion. If life in general calls for a special kind of respect or concern from us, then torture, insofar as it aims to transform life into a kind of anti-life, must be morally offensive in a way that is different from, and perhaps greater than even killing someone. Thank you.
Professor Sussman has eloquently explained why torture is wrong, extending his splendid article in Philosophy and Public Affairs. But sometimes we feel justified in doing what we know is wrong because the stakes are so very high. So the next question is whether torture is so wrong that it is inexcusable, no matter how high the stakes are. I will argue that torture is never excusable in any real case, in spite of the fact that we can imagine hypothetical cases like the notorious ticking bomb cases in which it might be excusable. Indeed, the case of torture raises important methodological issues about the use of imaginary examples. Two methodological issues in particular. First, idealization, which is the addition of features to an example that make it better than reality, and abstraction, which is the omission of features from reality from the example, making the example better than reality. Idealization adds sparkle. Abstraction removes dirt. Both make the hypothetical superior to reality and make the hypothetical a misleading analogy. Everyone who thinks about torture loves a ticking bomb. Just before I left England, the BBC correspondent asked Richard Pearl about torture at Guantanamo. Did Pearl discuss Guantanamo? Not on your life. He discussed the ticking bomb hypothetical, as unlike Gitmo as anything could be. In the case of Pearl, this was simply intellectual dishonesty, switching from the subject you know you cannot defend to the subject you think you can handle. But even the honest and thoughtful are mesmerized and bedeviled by the ticking bomb hypothetical with its suggestion of a catastrophic outcome, avoidable only through torture. In his article in the anthology titled Torture, a Collection, edited by Sanford Levinson, law professor Owen Gross writes, quote, "The foregoing discussion still leaves us with the question of what constitutes a truly catastrophic case. I will attempt to answer this question, which clearly is significant to the overall tenability of my project, on a different occasion. For now, it is sufficient to acknowledge that some catastrophic case is possible," end quote. Just above, Gross has quoted Carl Schmitt, declaring in Germany in 1922, quote, "For legal order to make sense, a normal situation must exist," end quote. And Gross has concluded, quote, "General norms are limited in their scope of application to those circumstances in which the normal state of affairs prevails. Catastrophes undermine this factual basis, end quote. Now, one problem here is the easy assumption that no catastrophes occur in normal times. This is one of many reasons it's not true that it is sufficient to acknowledge that some catastrophic case is possible. We need to know a great deal about a specific catastrophe to determine whether it is evidence that times are not normal to such a degree that legal order does not make sense. But there are deeper problems here than circular definitions. Gross is sometimes flattering about my 1978 article, Torture, but what he says about possible catastrophes possibly avoided by torture suggests to me that he has missed the fundamental methodological point concerning how to think about torture. This emboldens me to begin by repeating myself, attempting to be more clear. The ticking bomb hypothetical is supposed to be the case in which the disaster that torture might prevent is so catastrophic that only the naive and the utopian would dream of choosing not to torture the person who is somehow known with certainty actually to be the person who planted the ticking bomb. He is not a suspected terrorist. It is built into the hypothetical. He is a terrorist, the terrorist, thus eliminating messiness like uncertainty. Now, before I plunge back into the intricacies about the practical significance of the imaginability of such pure cases, I want to acknowledge one way to short-circuit the debate, which is the source of my title, Exceptionalism Cubed. It is apparently possible to believe that there is no reason to wrestle with extraordinary hypotheticals because the actual situation is so extraordinary. So I'd like to provide this thought with a quick cold shower. The first firm fact to note is that the laws of armed conflict already assume that the situation is exceptional. The laws of armed conflict are the rules for exceptional situations, situations in which, for example, mutual slaughter is not considered murder. So the fact that there's a war on, if indeed there is, means that ordinary morality and law do not apply. What applies are the laws of armed conflict. But the laws of armed conflict absolutely prohibit torture. For any argument that torture is now permitted to get going, the case that has to be made is that the current situation is an exception to the exceptional kind of situation that makes the laws of armed conflict relevant. We need at least exceptionalism squared. But if what is supposed to be exceptional is the war itself, it must be more than simply a new kind of war. Every war is somewhat new. This is why the standard criticism of generals is that they're prepared to fight the previous war. The war would need to be exceptionally different in respects that somehow transform torture from anathema to necessity. And then one could throw in good old-fashioned American exceptionalism, and one would have exceptionalism cubed. America, the one alcoholic in history who can take only one drink. America, the one nation that can torture judiciously and selectively. I find this line of argument too implausible to pursue, so I return to the beloved hypothetical. Idealization. I don't want to take much time detailing the perfections of the hypothetical. That was one of the main things I tried to do in the 78 article, and I think that point's widely accepted. But quickly, above all, the torturer in the hypothetical has the right man. Not 100 men of whom 10 might or might not be right, not a Navajo that someone thought looked like an Arab. The torture victim talks in a timely and accurate fashion. He quickly provides the crucial information. He doesn't have a stroke or a nervous breakdown or tell a plausible diversionary lie. Above all, this is a rare, isolated case. It doesn't spread and become routine, bouncing from state penitentiaries to Gitmo, to Bagram, to Abu Ghraib, and back again. Now, my weaker thesis was, do not base general policy on exceptional cases. Hard cases make bad law. My stronger thesis was, don't base anything on imaginary cases. One comment I made, which Professor Gross quotes, was, artificial cases make bad ethics. Of this, he writes, quote, its problem lies in the fact that ticking bomb cases are not artificial. They are real, albeit rare. Ignoring them completely by rhetorically relegating them to the level of artificial is utopian or naive at best. There's a difference between ignoring completely the truly catastrophic cases and focusing our attention elsewhere when designing general rules and policies, end quote. So Gross and I agree on the weak thesis. Don't base general policy on exceptional cases. But we disagree about what else, if anything, to base on the exceptional cases. Partly thanks to critics like Professor Gross, it's clearer to me now than it was in 1978, which is a long time ago, why ticking bomb hypotheticals seem artificial. It's because they are idealized. They're not simply imaginary, but unrealistic, like imagining an alcoholic who drinks 2 beers each night. There are former alcoholics who don't drink at all, and active alcoholics. But there's no such thing as an alcoholic who drinks moderately. And there has never, in human history, been a government that used torture selectively and judiciously, at least to my knowledge. I look forward to your telling me the name of one if you know it. Professor Gross is confident that what he calls catastrophic cases are real, albeit rare. But if catastrophic cases have only the one feature of having extremely high stakes, yes, cases with high stakes are real, albeit rare, perhaps not even so rare. But the high stakes are the realistic feature in the ticking bomb hypothetical, buried amongst several other features, all of which are too good to be true, especially not true in conjunction. The right man, the prompt right result, then the judicious decision, in spite of the wonderful result from the torture, to refrain from all torture until the next genuine catastrophe, almost certainly, looms. This happy conjunction is not rare, it's impossible, given the kind of people who rise to the top in politics. What would be utopian or naive would be to believe that the kind of people being appointed to high levels in the U.S. Justice Department would, if they had discretion about using torture, not choose to use it early and often. The Alice in Wonderland character of the assumption that the use of torture will not spread, in fact, throws into doubt the location of the catastrophe. Professor Gross, along with most people who appeal to the ticking bomb hypothetical, take it to be beyond dispute that the catastrophe lies on the side of not torturing. We're too squeamish to torture the man who planted the bomb, and the bomb explodes, bringing catastrophe. But the other possibility is that other nations reason that if the superpower cannot maintain its security without the liberal use of torture, they can hardly be expected to defend their security without even more use of torture. And what passes for civilization slides backward in the general direction of the 8th century. That, too, would be a catastrophe. I'm not predicting the return of barbarism. I'm simply noting that idealizations that make the danger evaporate are uncertain guides. So, my honest belief is that stories that are too good to be true are not true rarely, but false, and that the ticking bomb hypothetical is too good to be true. This is torture by angels. But perhaps I'm mistaken in believing that the perfect time for torture will never arrive. I'm certainly not appealing to conceptual necessities. I'm offering my empirical judgments about the nature of politics and the nature of human beings. What if I'm wrong? Here, Professor Gross and I have a common problem. I think the exceptional case is in fact impossible. He thinks it's rare, but clearly possible. Neither of us claims to have ruled it out. If it comes, what do we recommend? abstraction. Here, I think, we both suffer from the methodological weakness of abstraction. We both think that torture should remain absolutely, non-derogably illegal. But we both also said that if a public official honestly, upon reflection, judged that the ultimate catastrophe loomed, and it could be prevented if and only if some one person, or maybe even some small number of persons, were tortured, he should act outside the law and conduct the torture. I say act outside the law to fudge some differences between myself and Professor Gross that I think are important but can't pursue now. As his comments in connection with his quotation from Carl Schmitt, which I mentioned at the beginning, indicate, Gross believes that the arrival of what he calls the catastrophic case heralds, or perhaps simply constitutes, the suspension of normality, which Schmitt claims is a necessary condition for the rule of law. This sounds backwards to me. It's when normal conditions are eroding that one really needs the rule of law. But that's the long story that we can't tell now. Gross believes the situation becomes, quote, extra-legal, end quote, which I find worrisome because it seems much too wholesale, although it would be unfair to him not to mention that he also insists on ex post ratification of the entry into the extra-legal. And if it's not granted, the official who decided on the torture can be punished criminally and sued civilly for violating the law against torture. I don't myself really follow the reasoning. If the situation is extra-legal, why should he be punished for violating a law that has presumably been suspended? But never mind. I'm glad the torturer will be punished if he gets it wrong. My proposal was much more limited and simple, perhaps simplistic, essentially that the torture would be or be like an act of civil disobedience, after which the torturer would face charges and trial. If the torture had really prevented the end of the world, the charges would presumably be dropped. If not, our reluctant torturer would at least know in his own conscience that he had acted for the best. The problem, which seems equally severe for Gross's suggestion and mine, is that our reluctant torturer would probably also be an incompetent torturer, very unlikely to succeed at what might well be his first try. Successful torturers must avoid sympathy and empathy, or they will go too easy. They must avoid anger and cruelty, or they will go too hard and merely knock the victim senseless or kill him, as has happened during U.S. torture in Iraq. Torture is not for amateurs. Successful torturers need to be real pros, and no one becomes a pro overnight. At a minimum, one must practice, perhaps do research, be mentored by the more experienced. In short, torture needs to be an institution with apprentices and experts, an institution of the kind it in fact always is. Now, this actually supports my earlier point about idealization, where all of a sudden we're going to find someone who can actually get the man who planted the ticking bomb to tell us where it is, rather than just knock his teeth out and learn nothing. But it is a problem for the attempt to allow for the exceptional case. The problem is abstraction. We've abstracted from the social basis, the institutional context necessary for the practice of torture. Either torturers have no clue what they're doing, in which case they should certainly remain totally prohibited, or some do have a kind of expertise. If there's expertise, we certainly want it in the exceptional, potentially catastrophic case. If we want the expertise, we need to maintain the organizations and networks in which the expertise resides. So probably Professor Gross and I have both been trying to have it both ways, and we must choose. I would choose to prosecute the torturers and their high-level sponsors. If we succeed at that, but the perfect time for torture comes, we will have to try to think of some other technique, at least equally likely to save us. It shouldn't be hard.
Okay, I face the difficult problem of having had to rewrite my paper while Henry was speaking. Because I've now got to respond to some of what he's saying. But I'll start out by saying that my attitude to torture is like my attitude to capital punishment, in that by temperament I'm strongly inclined to take a high-minded view of the morality of both by defending an absolute or categorical prohibition. But I find I can't really do that in either case, because I think that in principle there are cases in which execution or torture could be morally justified. And I'll try to explain why I think that's the case in a moment. Nevertheless, my conclusion will be the same as Henry's, and that is that in the world as it is, it's better from a moral point of view to prohibit both execution and torture in the law. Now, as Henry notes in his seminal paper on the topic, torture can be employed for a variety of different purposes. There's impressive authority for the idea that punitive torture can be permissible. After all, the gods of both Christianity and Islam are thought to practice it very extensively and indeed everlastingly in the afterlife. That's something to think about. But it's characteristic of philosophers to be unimpressed by appeals to authority, and I don't take that authority to be very impressive, and I think there's absolutely no moral case for the permissibility of torture for the purpose of retribution. I think that even if people can deserve to suffer, they certainly can't deserve to be tortured. Henry also points out that torture has been used for terrorist purposes, I think a bit less now than in the 70s and 80s in Central and South America. Still, I think there can be no moral case for terrorist torture. Yet I do think a moral case can be made for what Henry calls interrogational torture, that is, torture to extract information in certain conditions. And this is where I'm going to have to say some stuff about Henry's remarks on the ticking bomb example. But let me just say first, and this is a bit of a reference back to David's paper, and that is that I do agree that there are various things about torture as it's actually practiced that make it specially or even uniquely awful. And Henry in his paper and David in his remarks today and in his very fine paper in Philosophy and Public Affairs try to help us to understand exactly what it is about torture that makes it distinctively horrible. But I think that in itself can't be sufficient to show that it can never be justified morally. Now, I'm going to give you a variant of the ticking bomb case. I can already anticipate the groans when you hear that. But I think that what Henry has said makes it important for me to go ahead and do this, because I think that I disagree with Henry a bit about hypothetical examples here, because I think we disagree a little bit about what the purpose of these hypothetical examples is. The purpose of these examples, in my view, is to help us to understand what the fundamental principles of morality at work in this area are. These examples ought not to be a guide to policy. They don't tell us anything really about what the right policy ought to be. So this is where, of course, Pearl's strategy is dishonest and disingenuous. He's asked a question about policy. He appeals to examples that might be illuminating in trying to understand what the right principles are. But the cases may not have any particular implications for policy. Now, the ticking bomb example, which a lot of people invoke, I think is sometimes misunderstood. So I'm going to offer a variant to try to show you what the real function of that kind of example may be. when Henry discussed the example of the ticking bomb, he rightly called attention to the fact that what torture is supposed to prevent in this case is a great catastrophe. But I don't think that's an important feature of the example at all. And one of the problems with the ticking bomb example is that it compares torturing with killing. You torture in order to prevent killing. But some people have argued, with some plausibility, that torturing is, as an act, as an activity, different from, and in some respects worse than, killing. So perhaps we can accept that. But again, ticking bomb type examples may be illuminating. So let me give you one. And, again, it's going to have the features that Henry objects to. It's going to be abstract, it's going to be pure, and so on. But it's not going to involve the prevention of a catastrophe, and it's not going to involve a comparison between killing and torturing. Some people, as you know, when they discuss torture, focus a lot on the relation between the torturer and the victim. And I think in the world as it is, that's a very important consideration. So I'm going to abstract from that and assume that scientists have been very obliging in trying to eliminate that element from torture, and so they've invented what I'll call torture machines. And what these machines do, they don't inflict any damage on a person's body. They just directly stimulate the pain centers in the brain. They set C fibers firing, and they cause a lot of pain. But they can be programmed to operate without any human intervention in the process. So nobody actually needs to be there. There's no humiliation involved, no sexual abuse, none of that. Just the pure causation of pain. And now here's the ticking bomb, my version of the ticking bomb example. Suppose we've got a terrorist who's trying to achieve some political concession, and he captures one innocent person and puts this innocent person in a torture machine and sets the timer so that the torture machine is going to begin causing this person great pain in a certain number of hours from now. And we know about this because he's videoing it or something and transmitting the image to the government. Now, we capture the terrorist, as in the ticking bomb example, and we know who this person is, as Henry rightly says is unrealistic, and I actually was planning to say something about that in my own remarks. But now we've got this guy, and we buy our torture machines from the same supplier that he got his from, and we can put this guy in our torture machine and turn it on. We can even set the intensity level to a level lower than that he's got his machine set on. If that seems to us the only way that we can get the information from him, can we do it? Suppose we have a high degree of confidence in our ability to get the necessary information from him in this way. And I suppose that's the only way we can do it. In that kind of case, we have a choice. We torture him, or we allow his victim to be tortured by his machine. Now, what I think this kind of example shows is that there can, in principle, be a justification for the infliction of pain on somebody in defense of the innocent, as a means of defense. The justification here takes the same form as the justification for harming or killing in self or other defense. It's just that in this case, what we're doing in order to try to defend someone from being unjustly harmed is to inflict pain rather than to try to incapacitate someone in advance of his harming somebody else. And the principle here is that when we have to choose between one person's being tortured and our torturing somebody else, we should take into account that the person who is responsible for this forced choice that we have to make is the terrorist. And that makes him liable, I think, to be harmed in this kind of situation. He's not going to have any reasonable complaint if we do to him what he will otherwise do to somebody else. Imagine, if you will, what form of complaint he might have if we put him in the machine when he's got somebody else strapped in his machine, and he can, through his own voluntary action, make it unnecessary for anybody to be tortured. That's why I think this person is actually liable to be harmed in this way and would not be wronged if he were harmed in this way. And I just want to emphasize that point, that the justification here appeals to considerations of liability and not to considerations of consequences. So it's not that there's some catastrophe that we have to prevent here. It's one for one. And the justification I've given focuses specifically on considerations of liability, so that if the only way we could prevent the torture of the innocent person was by putting the terrorist's child in our torture machine, nothing I've said would justify that. Nothing I've said would go any way towards justifying that. It's only those who are liable. Now, of course, the problem here, the problems here are essentially pragmatic. And they're the ones that I think some of which Henry mentioned. If we've captured somebody that we believe to be a terrorist, how can we be confident that he's really a terrorist? How can we be confident that he's actually liable to any form of harm? How can we be confident that he has any knowledge that might help us to prevent some bad effect for which he would himself otherwise be responsible? How can we be confident that anything anybody tells us under torture is reliable? Now, there's a dialectic here, so I'm going to try to follow out the dialectic. The defender of legalizing torture might reply that in an effort to defend ourselves against terrorism, we simply can't have the sort of safeguards against mistakes, such as an impartial trial and so on, that we demand, for example, in implementing the death penalty. But, this person is going to argue, this is actually acceptable. Just as in war, it's acceptable to kill enemy soldiers without safeguards to ensure that they're in fact liable, without safeguards to ensure that killing them would in fact serve some important military purpose. We just don't know this in war. Soldiers kill other soldiers. We don't know anything about these other soldiers. We don't know what they've done. We don't know whether killing them is actually going to do any good or not. But we justifiably have laxer standards for killing in war than we have for killing as a mode of judicial punishment. So, according to the defender of legalizing torture, we should also, in the war on terror, accept a comparable lowering of standards for the practice of torture. That I think of as a counter-argument here. Now, to this, the opponent of legal torture can reply that in war there's not the same scope for mistake about liability or about proportionality. In war, it's sufficient for a person to be liable merely to be a member of the enemy military. If he wears the uniform, he's liable and may be killed even in the absence of any evidence that killing him will do any good. That's the rule that we have. Now, I think there are several reasons for thinking that it's not that simple. In fact, we do face the same problems when we kill in war. And this is something I think we need to think about. These problems do run parallel. The problem, for example, of killing in war and the problem of torture in trying to defend ourselves against terrorism. But as I'll say in concluding my remarks, I think they have to have a different solution. But here are just a couple of the problems that we face in war. One is that even if we take the distinction between combatants and non-combatants to mark the boundary between those who are liable to attack and those who aren't, the distinction between combatant and non-combatant is itself very difficult to draw, even in principle. And in practice, it's often very difficult to tell who has combatant status and who doesn't. Mistakes occur. Non-combatants are targeted and combatants are spared. But this is something that we tolerate. And the other problem is that, in my view, combatant status may be insufficient for liability to attack, and non-combatant status may be insufficient for immunity to attack. So I think, for example, that those who fight in a just cause by permissible means can't be liable to attack by their adversaries. So I think that what we have in the international law of war doesn't actually correspond to what's true about the morality of war. Okay, that's a bit of the dialectic that I wanted to provide for you, but I think we can put that dialectic largely aside because the real problem runs a little bit deeper. Even if, as I believe, it's morally wrong for soldiers to fight in the absence of a just cause, we can't, for a variety of pragmatic reasons that I won't go into here, make mere participation in an unjust war illegal. Wars are going to be fought, and they can't be fought without killing on both sides. So the laws of war have to permit soldiers on both sides to engage in killing, even if some of them are acting wrongly in doing so. But neither war nor police action requires torture. Torture can be banned, or it can be permitted. But like killing in war, it can't be forbidden to the unjust, but permitted to the just. That is, at the level of law, we can't discriminate between those whose aims are just and those whose aims are unjust. So, in international law, neither the legality of killing nor the legality of torture can depend on the justice of one's aims. In both cases, I think the law has to be neutral. It therefore has to permit killing on both sides in a war, as I mentioned, which means that it has to permit the killing of the just by the unjust. I think that's a real problem with the laws of war. But I think it's unavoidable. I also think that's bad enough. I think it would be absolutely intolerable for the law also to permit wrongdoers to practice torture in pursuit of unjust aims. And I think that's the deepest reason, the main reason, why we simply can never have any legal permission to torture. There's also the problem that Henry noted more than 25 years ago and that he gestured towards in his paper just a moment ago. It has to do with what David Lubon calls the creation of a torture culture. If torture were legal, but only in certain highly specific conditions, as Dershowitz suggests, there's no reason at all to believe that it could be confined to those conditions. If we've captured someone we believe to be a terrorist and think he might have some useful information, we're going to torture him as long as there's some sort of legal umbrella under which we can claim justification. I take it that this is essentially the sort of point that Henry was making. There are simply too many problems with making torture permissible as a matter of convention or as a matter of law, so that even if at the level of moral principle we can see that in some cases torture could be morally permissible. And I do think that this has some relevance. This is not just something that's of no significance legally. Nevertheless, I agree, for the reasons that I've given, that torture has to remain absolutely, categorically, and exceptionlessly prohibited in law. Thanks.
Okay, let's go at these three. Questions from the audience? All right, let me start. Henry, let me put you on the spot. From a methodological standpoint, how do you respond to Jeff?
Well, first, we actually agree about hypotheticals. I think Jeff put it exactly right, that there's great value for the understanding of fundamental principles of talking about hypotheticals. Also, most law schools would have to go out of business if one couldn't discuss hypotheticals. So I didn't mean to be, and Jeff understood me exactly correctly, I didn't mean to be launching a general assault on hypotheticals, but what I was launching an assault on is their use for arriving at policy, and that this seems to me what's usually wrong when people talk about the ticking bomb case. I also think Jeff is right that there's quite a different argument that can be made. The kind of argument that the ticking bomb case brings up is essentially a consequentialist override. You say, okay, torture's wrong, the consequences are so enormous, we'll let the consequences override. Jeff's argument's quite different. It's that the person you have, because of his own conduct, is liable to torture. And so it's not consequences override, it override what's right. It's an argument internal to what's right. And I think he's absolutely right. That's quite a different argument. Let's see. Why don't I leave it? I don't. This will turn into a general discussion. Let me leave it there and see what else anybody's interested in.
Yes, sir.
It seems to be fundamentally an ends justifies the means debate, which has gone on forever. And you seem to, you switch back and forth. The ticking bomb simply says that if the ends will inflict greater harm than the means, that it's justifiable. In approaching it as a practical rather than as a moral issue, we have already, as a species, accepted that ends can justify the means in political and international action by the acceptance of war. How then can you limit the application of torture, whether you look at the issue of what means and what restrictions can we put on the means, or looking at what ends would justify any available means?
Are you directing that question at one of the panelists, or is it up for grabs?
I just sort of threw that one up.
Can I?
Yes, Jeff.
Can I be permitted to say something? Because what I would like to say is that it was precisely the point of my argument that the ends don't justify the means. My point was to appeal to an altogether different form of justification, which isn't looking at comparisons between level of harm, but looking at who is liable to be harmed and who can therefore justifiably be harmed without being wronged. That was what I was concerned about, and that's presupposes a kind of disavowal of the idea that the ends justify the means. In my case, it may be that you need to you torture. There could be 10 of these guys who are getting ready to torture one person, and it might be permissible to torture 10 people who are culpable in order to save one person who's innocent from torture. This is precisely what I was trying to achieve when I said we could turn our torture machine to a lower level of intensity than the guy we're going to torture has his machine turned to.
Don't mean to interrupt, but didn't you start out by disavowing torture as a means of a retribution, as punishment?
Yes.
And that's exactly how you're justifying the use of torture as a preventative. You get the person who's done the wrong, and you can torture them, but not the person who hasn't done the wrong, like...
There's a difference there. It's the difference between liability and desert. In the case of desert, there's a kind of positive moral reason to see to it that somebody gets what he deserves, irrespective of what the subsequent consequences of that may be. In the case of liability, if there's liability to harm, there's no reason to harm somebody unless it's inevitable that somebody must be harmed.
How is that different from ends justifying means?
It's different from ends justifying the means because the ends justify only certain types of conduct that don't wrong people. It's not that the ends are so important that you can just do whatever is necessary and proportionate to bring about your ends.
Let's get some other voices.
So, for example, I did say, you can torture the terrorist, but you can't torture his child. Yeah. If it were ends justify the means, there would be no difference between torturing him and torturing the child.
Ma'am. No?
Looking at the essence of people who deal in torture, going back to what Professor Shue seemed to say, if you permit any type of torture, you have to have a group of people who have specifically been trained in how to torture, which seems to be one of the problems that we had with Abu Ghraib, that we had a group of young people who had no concept other than the fact that they were in power and these people weren't. So if you carry that logic further, then we have to have a cadre of people that we personally train for the sole purpose of torturing. which then says automatically that we go along with the concept of torturing. How do the three of you relate this to anything other than the fact you have to do away with all torture, or else you have to say, yes, torture is something that we're permitted to do?
David, you haven't really spoken to the issue. Do you want to speak to that question? The other two have sort of talked about it a little bit.
I'm sorry, I don't fully appreciate the force of the question yet. In part, it wasn't my. Could you repeat what the?
Could I just say something about it?
Jeff, go ahead.
I'll say a little something in response to that very quickly. We do already have a kind of these mechanisms in place. We do have to train interrogators, and we train them in techniques of the extraction of information that stop just short of torture. We train them in deception and emotional manipulation and disorientation and. That's right. Well, no, some people actually. We did actually send some people to Abu Ghraib who had training. It's just that when they left, they said to Lindy England or whatever her name was, soften these guys up, keep them awake for us, help us out. But the people who told them that were the people who were trained.
But shouldn't we then absolutely say that no one can do that type of forceful thing unless they have had this specific training? And by having this specific training, aren't we then saying that we go along with it?
Henry?
Yeah, I think you're right that it's really kind of all or nothing. And even although Jeff gave a very different argument from mine about why the person would be liable to torture, this problem about institutions still applies. I mean, suppose absolutely everything Jeff said in the abstract is right, so there are some people who are actually morally liable to be tortured. It's still true that if it's going to be done right, you need people who know how to do it right, and that means you need trained people. And there are actually people, there's a man named Arrigo in particular, who are doing sociological research on the kind of culture of torture. And so you can either just have a few people who beat people up, which gets no one anywhere, or you need a serious organization, which I think we have. And so if you want to get rid of torture, you've got to get rid of the whole business.
Well, there's the alternative of just outsourcing it. That is, if someone has
has
well-trained torturers
right.
who are doing it anyway, right, then you contract it out. They can be tremendously effective, and you have no, results.
Or you can do it with machines, like my one contribution to the debate.
Professor Chodash.
I just wanted to challenge the distinction drawn between principles and policies. The three philosophers on the panel, and here we are in law school, which I think is very much threatened by the notion that we look at hypotheticals only to distill principles. Well, could you elaborate on that a little bit? Because at the conclusion, you still do end up with a policy recommendation, right? To say what the law should or should not permit. And I'd just like you to explain to us how you do hypotheticals only to the production of principles, and what is the use of the principle if it can't be operationalized in some sort of policy sense?
Well, in some ways, the principle tells you something about the outcomes that you want to try to bring about or to avoid through the formulation, implementation, and enforcement of your policy. I gave an example in the talk of a case in which I think there's an inevitable divergence between moral principle and law, and that is in the fact that the international law of war permits soldiers to fight in an unjust war, provided they fight within the rules laid out by the doctrine of jus in bello. Now, I think that there can't be any moral justification for that. I don't think there can be any moral justification for saying, I don't think that you can say that it's justifiable to kill basically innocent people who are just defending themselves from your aggression in war, even if they're wearing uniform and carrying guns. But the law of war has to be different. It would be disastrous to try to formulate rules of war that were non-neutral and didn't distinguish, or that tried to distinguish between combatants who have a just cause and combatants who don't have a just cause. There's no way that can be operationalized. And so that's an example of the kind of divergence, but it doesn't mean that the principles here are unimportant. The principles constrain and guide our formulation of the law.
One more question, ma'am.
Hi. I'm thinking that maybe I don't understand your hypothetical, Jeff, completely, but I was very persuaded by Henry and David Luban's work on torture. I don't think you can find a justification either in morality or law. And what, in particular, I didn't understand is your liability theory. How can the torturer become liable for his own torture? That suggests to me some sort of theory whereby individuals can be stripped of their humanity and their human rights. And I don't understand, A, who makes the decision, and B, why the torturer can be stripped of their human rights, whereas I assume you think that individuals who are mass murderers or serial killers or rapists still get to have a trial by jury and all the constitutional rights that we normally accord, even terrible people who have done terrible things. And so I have a serious problem with, maybe I'm just misunderstanding it, because it struck me that you had this sort of unusual liability theory whereby you can do this to somebody because they're bad. And the other aspect of the hypothetical that maybe I didn't understand, if I understood it correctly, you can torture them regardless of whether the torturing will produce the information you want or not.
No.
And the reason is because they're bad.
No.
So maybe you could explain that a little bit more, but that's how I understood it, that since you're not a consequentialist, that whether or not the torture is successful is irrelevant to the hypothetical. If it is relevant to the hypothetical, then I think you fall into the same trap that all the other ticking bomb hypothetical purveyors fall into, which is you assume that the torture will produce the results that you want, and you are essentially an ends justify the means kind of hypothetical. That's where you end up, really. Because if you have to assume for the moral validity of your hypothetical that it doesn't matter. Right?
Okay.
So if you could just respond to
Yeah,
that.
no, I think that the idea of liability here is exactly the same as the idea of liability as it functions in our understanding of killing and self-defense. You're rushing at me with a meat cleaver, you're about to chop my head off. The only thing I can do to prevent you from killing me is to kill you. Now, does that mean I'm stripping you of your human rights? Well, it means that in some sense, yes, you have forfeited your right not to be killed by me in those circumstances. That's a matter of your liability. That's what you make yourself liable to. If you're trying to kill me wrongfully and culpably, and I kill you in necessary self-defense, then I haven't wronged you, I haven't violated your rights, I've acted with justification, and the justification appeals to the fact that you have done something that does mean that it's not wrong for me to kill you in those circumstances. Now, if the chances of my succeeding in killing you by shooting at you or something were very low, would I still be justified? I think probably so. It does matter that you think you have a reasonable probability of achieving the end. I was at pains to try to stress that my understanding of liability here is not retributive. It is not a matter of desert. It is not punitive. It's a question of how we're going to distribute harms if harms inevitably have to be distributed. If you make it the case that one or the other of us has got to die, then I think, and you do this culpably, then I think it's just to distribute the harm of death to you. Similarly, if you make it the case through your own wrongful action that one or the other of us has got to be tortured, I think it should be you.
I'm afraid time's up. We're going to take a 5-minute break now. I think we have been engaged, and we have the panelists to thank for that.
All right, so we'll be reconvening at 11 o'clock for the next panel.
Sorry, you didn't get any questions. That's
Not surprised.
Yeah, you can just go ahead.
Sorry, David, again.
I didn't really expect that.
Pretty amazing. I'm Michael Shue.
Yeah, hi, nice to meet you. Good. Oh, thanks for having me. This is wonderful.
Pleasure.
This is wonderful. Yeah,
Thank you.
yeah, thank you. No, I felt so embarrassed.
Nothing you did was anything I was. I thought you did a beautiful job of it. I can never do that. I can't even answer the question.
Well, I hate to